All right, we're going to get started. Thank you again for being here this evening. My name is Barb Van Hoy, and I'm a policy analyst with the city's Community Development Division. It's my pleasure to welcome you to our second Renter Rights 101 workshop of 2021 with some great partners who I'll be introducing soon. These events are produced in partnership with Colorado Legal Services, the Pikes Peak Library District, and the Justice Center, and we also have Colorado Housing Connect joining us today. Before we dive into the program, I wanted to share a little bit about just the presentation format and some of the logistics for the meeting. So we do have the opportunity to show captions in several different languages. So at the bottom right of your screen, you'll see that little gear icon. You'll have a chance to add captions. And then you should be able to find the Q&A box where you'll be able to ask questions of our panelists or our speakers today. And please feel free to send those at any time while we're going through. All the participants are muted, and if anyone has the option of unmuting, please, we want to keep the background noise down, so please do stay muted. Also, I know some of you signed up to register for the event with the Justice Center, and if you have not done that, you still can, and then we'll have your email address and we can follow up with you. We will be sharing the slides and probably the video as well after this presentation. Tonight, our partners are going to share some great resources, and we'll hear from an experienced attorney who will share legal rights of renters. One thing we also wanted to do is just get a little sense, if you would, of who is here. So we're over a year now into the pandemic life, and without that, we would be together in a room and being able to connect with each other. But since we can't right now, we would love to just hear from you. What's your name? Why are you here? Are you with an organization? Are you a renter? Are you a landlord? Are you an advocate? It'll just kind of give us a little sense of who else here and a tiny bit of connection in the pandemic time. So even before that pandemic started, there was a housing crisis happening in this country, and that has only been exacerbated by the pandemic. It's been one of the top concerns in Colorado Springs, as well as almost every city in America. It's a top priority for Mayor Suthers, for sure, and it's an issue that the Community Development Division dedicates a large amount, if not most of our time to. So the Community Development Division of the City of Colorado Springs manages our entitlement funds from the U.S. Department of Housing and Urban Development. And as it turns out, next week is Community Development Week. And if you're connected through our email list or on social media, next week we're going to be sharing a lot of great information just to raise awareness among the community about what the Community Development Division does. But generally, we are charged with preserving affordable housing, preventing homelessness, and improving struggling neighborhoods. By providing practical resources for renters, we help achieve these goals. Ensuring renters and landlords know their rights and responsibilities helps prevent unjust evictions and to keep people housed. And housing stability is one of the most important goals of our division. So that is why we are here. So without further ado, I'm going to introduce our first short resource speaker, who is not short of stature. Just a quick resource description. Deb Hamilton is, where did my introduction go? Deb Hamilton is the Strategic Services Librarian for the Pikes Peak Library District, and she oversees the law and legal resource collection for the district. She's chair of the board of directors for the Justice Center and is also a member of the Access to Justice Committee for Colorado's 4th Judicial District. The really cool news is that her book, Helping Library Users with Legal Questions, Practical Advice for Research Programming and Outreach, is scheduled to be published this year by Libraries Unlimited. So be sure to look out for that. And if you'll give me just a moment, I'll be able to add Deb to the screen. There she is. Oh. Welcome, Deb. I think you should be able to replace those slides with your screen.
Okay, yeah, let me see if I can get mine up. Okay, can you see my screen?
Looks like it'll be up there in a moment. I will help.
Barb, is my screen up for everyone to see?
I am getting a little bit of connection problems. Let me see if I can get that going. Thanks everyone for your patience. Let's see. Seeing a couple people frozen. All right. Okay, you're up, Deb. Hopefully you'll be able to do the share. If not, I can give it a try also on my end.
Okay, it looks like on my end it's sharing my screen, but I'm not sure if that's what you all are seeing.
I don't think so. I'm going to give a try. Oh, I think I've got it to add your screen. There it is. Okay.
Okay.
Seeing the women's
all right. Okay, great. All right, well, thank you everyone for being here. As Barb said, my name is Deborah Hamilton. I work for the library as the law librarian. If you're not aware, Pikes Peak Library District does have a legal research collection at our downtown Penrose Library. That's at 20 North Cascade. What I want to show you right now are just what we have available through our website. So if you go to ppld.org, that'll bring up this page. And then I'm just going to go over here and click on to research. This will bring up all of our research guides, and then I'll scroll down here and find law and legal resources. There's actually quite a bit of content on here that we won't go through all of today, but we do have a number of databases that you can access. And then below you'll see here are a number of different kind of sub guides within here. I just want to point out two to you. First, in special legal topics here, you'll find a section on landlord-tenant laws. And then below that, I've also pulled out some eviction information and resources. So there you'll find more information about the process of eviction, the laws surrounding that, as well as a lot of the community resources that are available right now. So there's some great programs out there with rental assistance for COVID, and so all of that information is going to be housed here on this eviction information guide. Below that, you'll find some featured resources. So shortly, you're going to hear from Britt Kwan from the Justice Center. So there's a link to their organization, talks about their weekly legal clinic that they do each week. Colorado Legal Services, our presenter Clinton Albert works there. So there's information about their organization. In Clinton's presentation, he's going to talk a little bit about the Colorado revised statutes. So you'll see some CRS numbers. If you want to read those in full, you can just click on this link here. That'll take you to those laws. And then the Colorado Judicial Branch also has a really good website. In there, if you go onto that page, look for self-help and forms at the top. And then if you go into housing cases, that's where you'll find all of the forms related to the eviction process, as well as information about unlawful eviction. So if you feel like that's something that's happening to you, you can go there for more information. And then if you need to reach out to me, there I am. You can email me, you can give me a call. So please feel free to get in touch if you have questions about finding any of the things that you hear about tonight or just want some more information. I'm happy to connect with you and kind of point you to the right source. So that's all I have to share right now so we can get to the meat of the presentation. But thank you all for your time and for being here.
Thank you so much, Deborah. We really appreciate it. And now I'm going to introduce Britt Kwan. So Britt is the Executive Director of the Justice Center, which works in the Pikes Peak region to increase access to justice and to legal services. And they do that by, well, she'll talk more about it. I will let her describe that. And Britt has 9 years of experience in the nonprofit industry, and of course is passionate about leveling the playing field. And Britt, let's see if we can let you share your screen.
For some reason, it's not letting me share my screen. It made me restart. So if it's okay, can I have you pull up our website and I'll just kind of walk folks through it from your end?
Yep.
Got a spinning wheel of death right now, so I can't see anything, but I'm hoping it's working on your end.
It is. I do believe it is. Let me find that window where I've got that up. Thanks everyone for your patience. Right. Let's see if I can.
Thanks, Barb.
Okay, I'm not sure we're quite there yet. Okay.
Let me know.
And now it's live.
Okay, great. So I'm with the Justice Center. We provide legal aid in the Pikes Peak region. Some of our main things, if you scroll down just a little bit, Barb, for me, we have a few choices down here. Our main things are free legal clinics, free and reduced cost lawyers, and specifically what I wanted to highlight for you tonight is the tenant toolkit. So if you don't mind clicking on that, I'll take you to that page. This is a new conglomeration of resources that we've pulled together in the last month. So we've got a few things on here that I'll highlight. We've got housing videos, and we won't click through each of these, but we've got about 7 or 8 videos which talk about different housing topics. So if you want to go into the, get into the weeds about reading your lease correctly, what to do with the security deposit, what about evictions during the moratorium? Let's see, we've got stuff on animals and housing and warranty of habitability and how to request a reasonable accommodation. So if you want to dive into those topics more, we've got some housing videos on it. We have a link to forms and documents at the top as well. So there's a couple sample forms there. If you'd like to use those, you're welcome to. And then at the very bottom, we have a new housing ambassador program. So if you are somebody who's a tenant and you enjoy connecting with other tenants, you're passionate about renters' rights, and you want to get involved, we have an ambassador program that we're just launching this year. There's 3 tiers that have compensation associated with each level, and essentially just asking you to be ambassador for renters' rights in your sphere of influence. So if you're interested, there's an application on that page, and I'm happy to answer more questions about that too, but maybe you can put them in the chat. And that is it. I'll leave our website link in the chat as well.
Thank you so much, Brett.
Mm-hmm.
And next I want to ask Pat, did you want to, are you able to provide a little bit of information for us, or were you just going to answer questions?
Absolutely. I would love to share a little bit about Brothers Redevelopment and who we are and what we do.
Great. I will get you up here. Pat, thank you so much for being with us. Patrick Noonan is the program manager for Colorado Housing Connects.
Well, thank you so much, Barb. It's a pleasure to be here today. Brothers Redevelopment is a housing nonprofit, and we are celebrating our 50th year as an organization this year. One thing that Brothers Redevelopment does is operate a housing helpline called Colorado Housing Connects. If somebody has questions about finding affordable housing, finding rental assistance, maybe they have a family member that's a homeowner that's looking for resources. It could be a wheelchair ramp going into the home, something to do with health and accessibility in the home. Really any sort of housing question, Colorado Housing Connects is here to help. We receive inquiries through our website and through our telephones. We have housing navigators in Colorado Springs, and we have a Colorado Springs office. Sometimes people, through reaching out to us, will get connected with a housing counselor. A housing counselor can help somebody understand their budget and their credit. How can they really prepare to find that next place to live? Maybe they're tired of renting and want to figure out how they can buy a home. We do first-time home buyer classes and try and help people prepare for home ownership. But whatever it might be, we're here as a resource for you. I posted our information in the chat here, and hopefully it's available for you to see. You can visit us on our website, coloradohousingconnects.org, or by calling us at 844-926-6632. We'd love to hear from you. As a nonprofit, our services are free to anybody who might reach out. And really, all you need to have is a housing question, and we'd be happy to work with you and figure out what resources might be out there in the community. Thank you very much.
Thank you so much, Pat. We really appreciate you being here. All right, so now I am pleased to introduce Clinton Albert. He is a housing attorney with Colorado Legal Services, where he has served for 3 years. At CLS, his caseload is made up solely of landlord-tenant matters and covers a broad range of legal issues within that area. He's been presenting renter rights series now since 2018, and when not practicing law, you will likely find him in the outdoors hiking and climbing, like many of us in Colorado. And Clinton, I will work on getting your slides up. Thank you so much for being here.
Oh, thank you for having me, Barb, and thank you everybody for making the time this evening for the presentation. I think I was sharing my slides. Are they showing up for other folks?
I believe so.
Yeah. All right. Well, so tonight there's a lot of material to cover. I do intend on taking questions at the end, and also if there are relevant questions asked during the presentation itself, I'll do my best to stop to try to address those. Just a few things to keep in mind here. This presentation is for informational purposes only. We're going to be covering a lot of topics this evening. Housing issues require thoughtful analyses of both the facts and the law that surround the case itself. So while it may seem like a simple question, there's a lot of analysis that would have to go into it. Additionally, and I'll lead off with the COVID protections, those have been changing on a near monthly basis for about a year now, and would also require a case-by-case analysis depending on the timing of the case. So if you are a low-income citizen or a senior citizen and are facing a housing issue, you may contact Colorado Legal Services at 719-471-0380. And I do have it listed as in-person there. Please, I would recommend at this point to apply online at www.coloradolegalservices.org. So let's start with, starting off here is kind of one, in my opinion, what's been at the forefront of most tenants that I've spoken to over the past year is, well, is there any protection from the pandemic? And over the last year, we've seen protections come from the state level and the federal level. Currently, at the state level, it would be Executive Order D 2021-073. What does it do? It's in effect from, well, first of all, it's in effect from yesterday, March 29th, for another 30 days. It extends to previous executive orders, but realistically, what do these orders say? No late fees, and the Consolidated Appropriations Act is the law of Colorado. All right, what's the Consolidated Appropriations Act? Well, previously that was the act which extended the CDC eviction moratorium through the end of January. That moratorium has since been extended through the end of March, and as we will discuss here in just a minute, it is now extended through the end of June. However, as I indicated earlier, there have been a slew of executive orders. these executive orders, as you can see, they have all expired. You can see the dates that they were in effect, and there are also links everywhere. And I will provide a copy of these slides after the presentation. I will email them to Barb to hopefully they'll be able to be distributed. But you can see the time range for everything there. Now those expired orders still matter, and they matter because the orders themselves often interact with each other. So for example, just because order 285 expired on December 31st, that doesn't mean that order 307 did not extend part of that order. So if you have, say, an old demand or an old notice to quit, there may be specific protections afforded to that document from a past executive order. More importantly, if you're also disputing late fees that have been assessed to you, a lot of these executive orders did bar late fees for certain time periods. Moving on to the federal level, the protection in place at this point is the CDC eviction moratorium. That's the full name of it there. As I stated, it was recently extended through June 30th, 2021. What it states and what it is that landlords, owners of residential property, or other persons shall not evict any covered person. All right, so what is a covered person? Well, it's any tenant, lessee, or resident of a residential property, and this is key, that person has to provide to their landlord, the owner of the property, or other person who has a right to pursue an eviction, a signed declaration, and that declaration is signed under the penalty of perjury, and it indicates the following: that as the tenant, you are using your best efforts to obtain all available government assistance for rent or housing, that you expect to earn no more than $99,000 in income for this year, or $198,000 if you're a joint tax filer. You are not required to report any income in 2019 to the IRS, or you received a stimulus check pursuant to Section 2201 of the CARES Act. Number 3 is that you're unable to pay your full rent or more make a full housing payment due to a substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. You're also using your best effort to make timely partial payments that are as close as possible to the full payment amount, taking into consideration your individual circumstances. So any kind of medical bills, any other kind of non-discretionary expenses that you may have, you're allowed to spend that money on the things that you need and still be a covered person for the purposes of the CDC eviction moratorium. Lastly, if you are evicted, it would likely render you homeless or force you to move into a shared close quarters in a new congregate or shared living setting because you have no other available housing options. Here's a form, and as you can see, the expiration date on this is January 31st, but at this point, it's a fairly complete declaration form. I have not seen the new one that has a date of June 30th out there yet. There is one floating around on the internet with a date of May 31st. However, the law for the CDC moratorium is still in place, at least in Colorado. And there are some court challenges that have been going on. However, currently those cases are not binding upon Colorado courts. So does this eviction moratorium prevent all evictions? No, it really does not. Evictions can still proceed for criminal activity on the premises, threatening the health or safety of other residents, damaging or posing an immediate and significant risk of damage to the property, violating building code, health ordinance, or similar regulation relating to health or safety, or violating any other contractual obligation other than the timely payment of rent or similar housing-related payment. Keep in mind that this eviction moratorium does not waive the rent, and that as a tenant you are still required to pay the rent. You just cannot be removed by the sheriff for non-payment during the moratorium. And keep in mind that that only applies to covered persons. Once the moratorium ends, tenants are still responsible for any unpaid rent. Oops, that's a typo. Sorry, everybody. It's currently extended through June 30th. And as you can see, I have the link there to the moratorium for April through June 30th. So that would be the new order that was just released this week by the new CDC director. Let me check the chat real quick before I move on here. And All right, seeing nothing at this point, I will just be moving on. Now, this presentation is kind of geared up, thinking about when you're from the day you move in to the day you're moving out. So things to keep in mind as you're moving into a new residence. Well, first of all, there's been a new law that's gone into effect this year, and it bans income discrimination. So there are some exceptions to the law, but it is an unfair housing practice to discriminate against a person based on the source of their income. What a source of income means? Well, I think more important, it means you can't deny somebody because they're using a voucher. So source of incomes means any lawful and verifiable source of money paid directly, indirectly, or on behalf of a person, including income derived from a lawful profession or occupation and income or rental payments derived from any government or private assistance grant or loan program. And there is a link to the new income discrimination ban down there at the bottom. So keep in mind, and this is critical, and I really can't express this enough, but do your best to put everything in writing. A lease and anything after any other agreements are contracts between you and your landlord. Oral leases are valid in Colorado. However, the terms of those leases are going to be much more difficult to prove. They are presumed to be a month-to-month lease. And for example, if somebody tells you verbally but won't put it in paper, I want you to live here for the rest of your life, that's probably not going to be enforceable because there is no end date on that contract. As you're applying for places, please, it's important to keep in mind that you do have some rights as it relates to rental applications and the application fees. Landlords are not allowed to charge an application fee unless the landlord uses the entire amount to cover its costs in processing. Those costs may be the actual expenses in processing the application or the average expenses if a landlord has multiple applicants per unit. So kind of the average cost of processing that application. Landlords cannot charge different amounts to different applicants. And as a landlord, you are required to provide the applicant with a disclosure for the anticipated or actual expense it's going to cost to process the application and provide a receipt for the application fee itself. Landlords must also make good faith efforts to return remaining amounts to applicants. So if you are taking applications, perhaps a forwarding address where you can send any notifications at this time would be a very good information to include in that application form. So as you're applying, if you're concerned about maybe past rental or credit history, please keep in mind that the landlord is restricted in what they can consider. Landlords can only take the past 7 years of rental or credit history into consideration when processing a rental application. Anything older than that cannot be a reason to deny, shall not be a reason to deny an applicant a residence. So what about criminal history? What about arrest records? Landlords, you can't take arrests into consideration. That is not a valid reason to deny someone a residence. You can take certain convictions into consideration though. What are those convictions? Well, you can't, it has to be 5 years or newer unless it is generally related to methamphetamine. There's maybe an exception or two under there, but a lot of methamphetamine related statutes are can be used against you as a tenant for longer than 5 years. Any conviction or any offense that requires a person to register as a sex offender, homicide related criminal offenses, and also stalking. Those type of convictions can be used to deny an applicant if they are older than 5 years. So what happens if your application is denied as a tenant? Well, if you're a landlord, you have to provide that applicant with a written notice of the denial, and you have to state the reasons for the denial. And you also have to provide this writing to the applicant within 20 calendar days of your decision to deny the application. What happens if the landlord doesn't follow the law? What if you don't make that? What if you don't put the decision to deny in writing? What if you don't state the reasons? What if you use credit history that's 8 years or older? What if you use a theft conviction that is 10 years old? Well, an applicant can seek 3 times the amount of the application fee, court costs, and reasonable attorney fees if a landlord violates this law. However, similar to a security deposit, which we'll talk about later, as an applicant, you must give the landlord a notice of your intention to file the actions at least 7 days before filing the lawsuit, That gives landlords, that does give you the ability to cure the violation. If a denied applicant brings a meritless claim, then they will be liable for the landlord's court costs and attorney fees as well. And those are the statutory sources for those, as Deb was indicating earlier. If you want to follow up further with those, you're more than welcome to research those on the PPLD webpage.
Hey, Clinton, can we
Yes.
pause for a question here? It says, under
Absolutely.
the new source of income law, can a landlord refuse to accept a cosigner for a tenant?
That is a very good question. The answer is I don't know, because as we just kind of covered there, they would have to put the reason to deny in the letter, in the denial letter itself. And as I stated, there are some exceptions to the income discrimination, unfair housing practice law. So it is possible that it is not permissible to deny a cosigner, given that if there are no other reasons. So Stephanie, I believe Katie's going to be handling that question, but to kind of get back to the question about the cosigner, and this is why it's hard to give kind of advice in a vacuum or an analysis in a vacuum, is the answer is it depends. So it's going to depend on a number of factors in that case. If you do have that documentation, I would strongly suggest that you reach out for further assistance in the matter. Moving forward, and the next step is, if you're at, let's say the application has now been approved and you've been given the lease. Again, it is critical to read the lease. Read it line by line. If it's 50 pages, sit down and break out a magnifying glass and a bottle of water and read all 50 pages. What's the length of the lease that you're signing? Because whatever you talked about beforehand, what's written on the paper is what's going to count. Is this a month-to-month lease, a year long, 2 years? What happens at the end of that original term? Does it automatically roll over? Or does your landlord have to agree to that? Or does it automatically terminate and there's no chance of a rollover? What about, even though they're barred right now, what about late fees, utility fees, anything like that? What responsibilities for upkeep of the residence and maintenance, especially if you're in a single family home with a yard? Are you responsible for keeping up that landscaping? Other sections to keep an eye out for in the lease itself. A notice related section. Is your tenancy an exempt residential agreement? That means that you would only be entitled to a 5-day demand for a notice for demand for payment or demand for compliance. Also, be sure to review for sections related to the warranty of habitability. First of all, which appliances are included in the lease? If an appliance is included in the lease, then there's an argument that that's a condition that would be subject to the warranty of habitability if that appliance then becomes inoperable while you're living there. Also, let's say that you do run into a warranty of habitability issue. What is the email address or portal address where you are to send your electronic notice of the warranty of habitability issue so that your landlord is on notice and takes proper steps to remedy the problem? So now, just to spend a little more time on exempt residential agreements, these are only single family homes. These cannot be apartments or condominiums. These are single family homes that are leased by a landlord who owns 5 or fewer single family, rental homes. There must be notice provided in the lease that the 10-day notice period does not apply to the tenancy. So that means that an oral lease cannot be an exempt residential agreement. And what an exempt residential agreement does is it lowers the amount of notice that a tenant receives for non-payment or a lease violation from 10 days to 5 days. What are some things in the lease that are not enforceable? In your lease, you cannot waive your right to the return of the security deposit. You cannot waive your right to the warranty of habitability unless there is a separate agreement that is supported by consideration and you have the skills to do so. What I mean by that is let's say you're an electrician and there's a separate agreement that you waive the warranty of habitability as it relates to electrical wiring because you have those skills. You cannot waive the covenant of quiet enjoyment, which is the covenant that you are able to enjoy your residence as a residence and able to use it for that purpose. You cannot waive a 5 or 10 day demand for unpaid rent. You always have that right. And you cannot waive the court process for forcible entry and detainer cases and eviction. So at the end of that lease, make sure that you get a copy of it. Keep a copy of it. Make sure that you save it in a safe place. You need a copy for your own records if there's ever a dispute. And the law requires that your landlord provide you with a copy within 7 days of you signing the lease. And the source for that right to a copy of your lease is right down there. That's going to be Colorado Revised Statute 3812-801. What about receipts? Since we're kind of on a paperwork subject matter here. Again, you have a right to receipts for your rent and your security deposit. If you pay in person with a cash or money order, you have a right to an immediate receipt. If you pay by mail with a cash or money order and you request a receipt, then your landlord has 7 days to provide you with a receipt for that payment. Now, if you pay by credit card or check, or let's say a Venmo or something on that manner, make sure that you're taking screenshots and keeping records of the payments that you're making. You don't have a right to receipts for those payments, but make sure that you're keeping copies of those payments to make sure that you're keeping the fullest and most accurate records that you're able to keep.
Hey, Clinton, does a townhome qualify for the exempt residential agreement?
Maybe. Again, I would have to, this is one where you'd almost have to look at the property documentation to see if it is categorized as a single family home. Because if it is categorized as a single family home, the landlord has 5 or fewer rental homes and it is written into a lease, then maybe it would qualify as an exempt residential agreement, but would have to look at further documentation to see if a landlord's able to get to that point. All right. And candidly, I have not come across a case with that level of that in depth on this issue. But if you do feel like your lease is not appropriate or that you should not be subject to an exempt residential agreement, I would encourage you to apply for further assistance on that matter. So now that we've gotten through the signing of the lease itself and you're getting everything loaded up, you've got the keys, before you start moving things into the residence, while it is still empty, take the time to document it. Go through, take pictures of everything. Take videos showing lights being turned on and off, showers, faucets, everything running. Why is this documentation important? Because it shows what the condition of your residence is at the beginning of your tenancy. Damaged or undamaged, document it. Show what your place looks like, show how things are working. At the end of your tenancy, this documentation is going to be crucial because if you move in and there's a hole in the wall and you move out and the hole's the same, you want to make sure that it's documented that that hole was there before you were, so you're not responsible for that. I would also suggest trying to schedule, and I recognize that this is maybe not feasible for a lot of folks right now, and a lot of landlords quite simply won't be offering this, and that would be to do a walkthrough. It's not required, but it is important to take this extra step so that you can identify any pre-existing damage and that you can enter into the contract with your landlord with the same understanding of the condition of your residence. Maybe you set up times for you and your landlord to do a walkthrough separately before you move in, and that way you can compare notes or pictures or just kind of put them on notice at things you saw that maybe they didn't see. Be critical, but not unreasonable. All right. You are not being a bother by pointing out existing damage. You are paying for this residence. Landlords have an obligation to deliver possession, but also as a landlord, you probably want to keep your property in as good a condition as possible so that a little repair today doesn't become a major repair tomorrow. Remember, this is a business relationship. It is regardless of how you knew each other before you became landlord and tenant, this is a business relationship, and it's beneficial for both parties to have the same understanding of the condition of the residence when you begin this relationship, because that may avoid disputes in the future. Also, in your lease, pay attention to any rules or regulations that are mentioned or rules or regulations that are referred to, but you don't see a copy of them. These are additional conditions of your tenancy. So if your lease references additional rules and regulations, make sure you get a copy of those. You may receive one with your lease, but if you don't, ask and ask and ask, because these are conditions of your tenancy. And if you break a rule, if you haven't read it, but let's say the lease says that you acknowledged it, then you may be at risk of an eviction. Are there quiet hours in the buildings? What's the grievance procedure for disputes? How do you contract for any kind of work to be done on the property? What about guest rules, visiting hours, anything like that? Just keep a lookout for those kind of rules and regulations in your lease or any addendums to your lease. One of the main issues that tenants will run into during their tenancy is going to be when there's a condition in the residence which really makes it difficult to keep living there. And the warranty of habitability is the promise that your residence is fit for human living. There are a list of things that by law must be present in your residence. That list can be found. There used to be when this presentation was in person, there was a packet. I believe that packet can be found on the city website at this point, if I'm correct. And Britt, if I'm
that's right.
That's right. Thank you, Barb.
Yes.
And Britt, is there a copy on the Access to Justice website as well, or did I not get one over to you?
You mean on the Justice Center website?
Yeah, sorry.
Sorry, and you said a copy of what?
The packet, the written packet that we used to be able to distribute in person.
We don't have a copy, but I can get it up if you can email it to me.
I will make a note to do that tonight, but there is a copy on the city website currently for anybody looking for that packet.
Clinton, what if landlords create rules and do not notify tenants?
Well, my quick response is they can create whatever they want, but if they don't put anybody on notice about them, how do they expect anybody to follow them? Also, if it's created without the tenant's knowledge, how can the tenant be put on notice that this is expected of them? So there would be a basic kind of notice issue there. If you're a landlord and you're changing rules, it really does you no benefit to not put your tenants on notice of those rules. So I would need more information to give more advice on that and more analysis. So if you are running into a case where there are being new rules imposed upon you without your knowledge or without any kind of notice, please reach out to apply for possible assistance. So earlier, a few slides back, I had referenced when we're reading through the lease to look for the electronic notice section related to the warranty of habitability. Now, what is electronic notice? A work order very clearly, I want to be clear. A work order is not electronic notice. A work order is not notice of the warranty of habitability. What makes up an electronic notice? It's notice by email or portal or management system that is available by both a landlord and tenant. And if you send it an electronic notice, you must send it to only the email, phone number, or portal specified by the landlord in the rental agreement. So go back to your lease for what is electronic notice. For example, if your lease says, you've got to email it to this email address and you send a text message to another phone number or email address, that's not going to be notice. What happens if your lease doesn't say where to send electronic notice? Then you can send it to your landlord in a way they previously communicated with you. So if your landlord didn't include that electronic notice section in your lease, but then sends you a text message, well, you can now send warranty of habitability demands or notices through text. If they send you an email, you can use that email address to send electronic notice to. You can also send an electronic notice and also hand deliver a notice as well. However you deliver this, if you send an email, make sure that you keep a copy of it. You must have sufficient proof of delivery. So when we're talking about the warranty of habitability, what conditions are we actually talking about? What are the things that may come up in your residence which would make that residence uninhabitable and have your landlord either do the repairs or you have the opportunity to maybe terminate your lease early. So
Hey,
here,
Quincy,
yes.
Before you jump into this, there's one about warrant of habitability here. If the warrant of habitability items are city specific, do they also apply in unincorporated El Paso County?
That is a very good question. The warranty of habitability items are not city specific. This list comes from the Colorado revised statutes. So this applies statewide. However, keep in mind that code enforcement may be different between jurisdictions, but code enforcement, and I will touch on this a little bit later, code enforcement and the warranty of habitability are two very separate subjects. But the conditions that you're about to see on your screen here, these are going to apply to you whether you live in El Paso County, Custer County, Denver, wherever. You have the right to conditions. You must have sufficient waterproofing and weather protection of your roof, walls, doors, and windows. You've got to have plumbing and gas in good working order, running water, reasonable amounts of hot water, proper fixtures and connections to sewage disposal systems. You must have functioning heating facilities in good working order and in compliance with the law, electrical, lighting, and wiring and equipment in good working order and in compliance with the law. The common areas must be kept under control. Common areas under control of the landlord must be kept reasonably clean. There must be an appropriate extermination in response to infestations. Bed bugs have their own kind of specific rules that we'll touch on in a second. Right here, in fact. So, as a tenant, if you know or reasonably suspect that your dwelling has bed bugs, then you have to notify your landlord quickly via written or electronic notice. Landlords, when you get that notice, you've got 96 hours to do the following. You've got 48 hours to give the tenant notice that of somebody's intent to enter your building, and you have to obtain an inspection by a qualified inspector. Landlords may enter the dwelling unit or any contiguous unit for the purpose of inspecting for bed bugs. If inspection confirms bed bugs in the unit that was initially complained about, then as a landlord, you've got to inspect all contiguous dwelling units as promptly as reasonably practical. All right. As a landlord, you're going to be responsible for all costs that are associated with an inspection for and treatment of bed bugs. So after that inspection is done, landlords then have to give tenants written notice within 2 business days whether or not the dwelling contains bed bugs. If the inspector determines that there aren't any bed bugs, they didn't find any, landlords, the notice must inform the tenant that if they still have concerns about the infestation, they may contact the local health department. If they confirm the presence of bed bugs, then the inspector must provide a report to the landlord within 24 hours. And then, not more than 5 business days after the inspection, the landlord shall commence reasonable measures to effectively treat the bed bug presence. That doesn't mean you hand your tenant a can of bug spray and say, have fun. You have to retain the pest control service. Tenants, you have to comply with the reasonable measures to permit the inspection and treatment. If you get a list of things that you need to do to ready your place for treatment, you have to do them. You are responsible for the costs of preparing your unit or your home for inspection and treatment. So if you have to buy bags to put all your clothing in kind of trash bags or Tupperware tubs, you have to cover the cost of that. If you knowingly and unreasonably fail to comply with the treatment and treatment requirements, you may be liable for the cost of any treatment of any contiguous dwelling units as well, if those units then need to be treated. So one way to look at this is, as a tenant, if you make a complaint to your landlord about bed bugs and your landlord then comes to treat the bed bugs and you refuse to let them in and your neighbors then become infested as well, you may be responsible as a tenant for the cost of those treatment if your refusal to comply was both knowing and unreasonable. Landlords, you are not allowed to rent a unit that you know or reasonably suspect to contain bed bugs. And if an applicant asks you, you have to tell them, to your knowledge, whether the unit contained bed bugs within the last 8 months or the date that the unit was inspected for and found to be the last date the unit was inspected for and found to be free of bed bugs. Landlords, if you do not comply with your requirements as it relates to bed bug inspection and treatment, you will be responsible for a tenant's actual damages. Landlords may, if you have a tenant that refuses to comply with the treatment, you may then apply for injunctive relief in court. You may take your tenant to court to try to get injunctive relief. As that way you can force access to the unit for inspection and or treatment. If you take your tenant to court and a court finds that as a tenant they've unreasonably failed to comply, the court may issue an order granting access to the dwelling, granting you as the landlord the right to inspect and treat, and requiring the tenant to comply with specific inspection and treatment measures, or assessing the costs and damages related to that non-compliant by the tenant. So we're still in the warranty of habitability here. Landlords, you are also required to provide an adequate amount of outside receptacles for garbage. If you are renting a 20-unit apartment building and you have one 10-gallon trash can outside, that's not adequate. Working floors, stairways, and railings. Locks on exterior doors and security devices on windows that open. You have a right to be secure in your residence. The residents must also comply with all applicable building, housing, and health codes, which may materially interfere with your life, health, or safety. Lastly, we also have mold. Mold is defined as microscopic organisms or fungi that can grow in damp conditions in the interior of a building. But mold's naturally occurring. So when is your residence going to be uninhabitable due to mold? Well, it's going to be uninhabitable due to mold when that mold is associated with dampness, or there is any other condition causing the residential premises to be damp, which condition, if not remedied, would materially interfere with the health or safety of the tenant, excluding the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. That last part there, don't air out the bathroom, wipe down the kitchen, check under the sinks to make sure that the sinks aren't leaking, those kind of things, all right? Now, if it's in the bedroom closet, that's a different kind of question. Earlier, I'd mentioned appliances when we were discussing reviewing the lease. Appliances are also subject to the warranty of habitability. More specifically, refrigerators, range stoves, or ovens included within the residence for the use of the tenant pursuant to the rental agreement or any other agreement between the landlord and the tenant. So it's those three are specifically mentioned by name in the statute. So if those three are included, then great. If you have other appliances that are listed, then those may also be covered. Okay, and that's the next bullet point here that you can see is that this only applies to the appliances specifically listed in a written agreement or otherwise actually provided by your landlord at the beginning of your tenancy. So as a landlord, if you do, in Colorado, air conditioning is not required, but a lot of landlords may provide an air conditioning unit. I would imagine that you would be able to write that while the air conditioning unit is included, that it is not part of the warranty of habitability. I don't think there would be anything improper about that. If as a tenant you make a demand based upon appliances and your landlord replaces the appliance, then there is a presumption that the replacement appliance is not installed in retaliation so long as it has substantially the same features as the original appliance. If there was a top of the line refrigerator with the touchscreen TV in it for some reason and that breaks and the landlord replaces it with a regular refrigerator but it doesn't have a TV, it's not retaliation because your refrigerator doesn't have a TV anymore. It still chills the food, it still freezes the food. If your refrigerator gets replaced, however, with say a little, lunch tote cooler type thing, I don't think that would be as substantial, and I do not believe that would be in compliance with the warranty of habitability. It is also a breach of the warranty of habitability if your residence contains a condition that materially interferes with your life, health, or safety. This is a more subjective standard because it is in my opinion, this is dependent upon your life, your health, and your individual safety, and that may be different than your neighbors, it may be different than mine. So this may need some support for this position. This, however, significantly alters a landlord's response. This is also kind of a catch-all. So if you ask me what does this mean, it's kind of one of those things where there's not a specific definition, but you're probably going to know it when you see it. Let's say somebody crashes through the front of your house and now you have a hole where a wall once was, or your house floods, or your house floods, and you've got 6 inches of standing water in the basement. So I've been kind of listing off all of the conditions that may breach the warranty of habitability. So when does that breach occur? When does a landlord breach the warranty of habitability? First of all, the residence has to be uninhabitable, and that's going to be as described by statute or in a condition that materially interferes with a tenant's life, health, or safety. That's all of those slides we had just been reviewing. And the landlord has received reasonably complete written or electronic notice of a condition and failed to commence remedial action by employing reasonable efforts. If you call your landlord and tell them about it on the phone, you have not put your landlord on notice of the warranty of habitability issue. You have told them, but for legal purposes, they are not on legal notice because there has been no written or electronic notice delivered to them. So when does a landlord have to commence remedial action? When do they have to start fixing the problem? There are 3 different timelines. For conditions that materially interfere your life, health, or safety, it's 24 hours. Condition that is uninhabitable by statute, 96 hours. And mold has a whole different one, which we'll talk about. It's got more intermediate deadlines in it as well. Statute, as you can see, 24 hours when the condition interferes with your life, health, or safety, 96 hours, statutorily described condition, broken windows, water, etc. But this 96 hours only applies if you have included permission for your landlord or landlord's agent to enter the premises. Now, mold is different than the other 2. Within 96 hours after receiving the notice, landlords, you have to install a containment stopping active sources of water to the mold, install a high efficiency particulate air filtration device to reduce exposure, and you have to maintain that containment until the following actions are executed. And that's to, within a reasonable amount of time, to establish appropriate protections for workers and occupants, eliminate or limit moisture sources, and dry all materials, decontaminate or remove damaged materials as appropriate, evaluate whether the premises has been successfully remediated, reassemble the premises to control sources of moisture and nutrients to prevent and or limit recurrence. So, tenants, once you provide your landlord with that habitability notice and the landlord gets it, do they have to give you a response? Yep. Landlords, you have to provide a written response. Again, you can't just call your tenant and say, all right, I'm going to have somebody come out there tomorrow. You have to put it in writing. So you've got to respond to a tenant's reasonably complete notice within 24 hours of receiving the notice. And that response has to contain your intention for starting the problem or for fixing the problem, an estimate on when you're going to start fixing it, and an estimate on when you're going to finish fixing it. What about an alternative residence? Some cases, yes, landlords, you do have to provide an alternative residence. If the residence is in a condition that materially interferes with your tenant's life, health, or safety, and your tenant makes such a request, then you have to provide a comparable dwelling unit as selected by you at no expense or cost to the tenant, or a hotel room as selected by you at no expense or cost to the tenant. You have to provide this. You are not responsible as a landlord for any other cost other than that alternative residence that arise after the relocation period. Tenants, you're still responsible for rent by the terms of your lease during this time, and it only applies to material interference with life, health, or safety. And landlords, please keep in mind that if you've been allowing pets in the residence, you should be providing your tenants with an accommodation that allows pets, because that's what you agreed to provide. So a hotel room which does not allow pets in response to a tenant that you have allowed to have pets, probably not a sufficient alternative residence. So what can a tenant do if the landlord breaches the warranty of habitability? So after, as a tenant, you've provided proper notice and you have not received a response and or your landlord has not started remedial action, you can terminate the lease. You can obtain injunctive relief in county court or district court. You can defend against an action for non-payment of rent by withholding rent, but don't spend that money. You are keeping that money aside because you're going to have to pay that to the court to be able to use this as a defense in court. There are also other monetary options. One of them, as indicated, is withholding a rent. you're going to need if you withhold rent, your landlord is likely going to take you to court to try to evict you for non-payment of rent. Your defense is that you did not pay your rent because your landlord breached the warranty of habitability. However, in order for you to be able to use this defense, you have to be able to pay the court the amount of rent that you withheld. So if there is a problem with the notice that you have provided to your landlord, then there will not be a defense based upon the warranty of habitability, because it may not be a reasonably complete notice any longer. Prior to withholding rent, I would strongly suggest that you seek legal advice before taking this step. Keep in mind that if your landlord is not responding, you can sue your landlord in court for the breach of warranty of habitability, and you can pursue actual damages based on your landlord's failure to respond. You can also deduct the cost of repairs from your rent if your landlord refuses to respond. This is a very specific process. If this process it also does not apply to everyone. Given how specific this process is, I think that if you're considering deducting the cost of repairs, that you should very much consult with an attorney first. You cannot deduct for repairs for certain issues. And if you wrongfully deduct rent, then your landlord will get a money judgment in that amount withheld, and you will also likely be evicted for non-payment of rent because you were wrongful in withholding and deducting the cost of that repairs. If you are making a bad faith deduction, then it is not only is an automatic eviction against you, but there will be a money judgment entered for 2 times the amount that you withheld. So this is an option, but it is, in my opinion, this is a difficult option. So if you are considering this, please seek legal advice before taking this step. Are there any exceptions to the warranty of habitability? Yep, there are. So if there is a written agreement that is separate from the lease, that is signed by both parties and is supported by adequate consideration, maybe that's a rent deduction, but it has to be supported by adequate consideration. As a tenant, you must have the skills to perform the work. Now, this is where you're carving out something specific. Maybe you're a plumber and you don't have to worry about the plumbing being in good working order because you can handle that. Maybe you're an electrician, but if you're like me, I have no skills to perform any of this work. So I would not be, if you don't have the skills, do not enter into these agreements. If you're unsure about whether this applies to you, please seek legal advice. And there were some other resources at the top of this before I kind of started talking, but keep in mind that there are resources around the community to address certain issues as it relates to the condition of your residence. Code enforcement, different than the warranty of habitability. Just some quick facts about code enforcement. They only have the authority to enforce the minimum housing standards of the city code, do not have the ability to enforce the warranty of habitability. Some issues are not included in the city code that are in the warranty of habitability, like mold. Mold is not in the city code. You can call both, but just to kind of, warranty of habitability is for court, code enforcement is for city code. So what about security deposits? These are things that get paid up front, but what happens at the end of your tenancy? When can they be kept? What can you do if your landlord keeps it? So landlords, when can you keep your tenant's security deposit? When there is damage beyond normal wear and tear, non-payment of rent, abandonment of the residence, non-payment of utilities, repair work, or cleaning work contracted for by the tenant. So this is what you can keep a security deposit for. This is the list. But what is normal wear and tear? The usual deterioration which occurs when living in a residence. What is not normal wear and tear? Oh, and by the way, carpets get older. Carpets lose value over time. You eventually will have to repaint the walls of a residence. This is normal wear and tear. What is not normal wear and tear? The careless or intentional destruction of property. Holes in the wall? That's not normal wear and tear. Broken windows? Probably not normal wear and tear. So as a tenant, what should you do when you're moving out? Clean the residence. All right, your lease probably has something probably has a section describing what your responsibilities are when you're moving out. Also refer back to your lease, but make sure that you clean the residence, get it in a broom swept condition. If you're able to vacuum up the carpets, do that as well. Do it. Try to do another walkthrough with your landlord if you're able to. Take more pictures. Try to take the same pictures that you took before, the same, just to show those same conditions after you're moving out. Return the keys to your landlord. This is crucial. Don't keep a key. Return them. If you keep a key, your landlord does not know that you're not going to come back because you still have the key. So make sure that you provide a key to your landlord, and also make sure to provide a forwarding address to them. It doesn't have to be where you're moving to, but just an address where you can receive mail. If you do not provide your landlord with a forwarding address, your landlord does not have to return your security deposit to you. So, how long does your landlord have to return your deposit or a statement of deductions from your deposit? Up to 30 days. Unless it is extended in the lease, it can be up to 60 days. So if it is an oral lease, then it's up to 30 days. If it is a written lease, make sure to refer back to your lease to see how much time your landlord has to return the deposit. What happens if your landlord does not return your deposit? Well, you're going to want to send a demand letter. I would recommend sending it, previously I would have said certified. I would say certified and also first class, just something with tracking to show that it was received. Certified mail has a tricky time getting to PO boxes. And you're just going to be kind of following it with delivery attempts, and then it's probably going to get returned to you after a couple weeks. Make sure to keep a copy of the letter. There's a sample letter in the materials that are on the city's website if you would like to refer to one. Here are a couple here. There really isn't any kind of magic language here. You're just saying that you've received you either have not received anything or you've received a statement of deductions and you disagree with those. Your landlord may only refund part of your deposit. Beware of any kind of restrictive endorsements, something that says acceptance of this is a full and final resolution of any and all disputes related to the security deposit. It may be something where if you cash the check, you cannot come back and say you owe me more money, you kept more than you should have. If you send your landlord that security deposit demand and you don't get a response to your landlord, you can initiate a small claims action if the amount is under $7,500. You can go to county court if it's above $7,500, but small claims is pro se, so it's party versus party. Typically, there aren't any attorneys. You can seek treble damages or 3 times the amount that was wrongfully withheld if you file your case within 1 year and a willful withholding is found by the court. Now, landlords, if you deliberately fail to return the security deposit during that additional 7-day period, which is the letter stating, I disagree, you have 7 days to send me my security deposit back, the retention after receiving that 7-day notice letter is logically willful under the security deposit section. And the case that ruling comes out of is listed below there. That's Turner v. Lyon. What about an early lease termination? It's rare that that's permissible, but sometimes the lease permits it. So if you're looking at that as an option, make sure that you review your lease to see if you're able to do that. A breach of the warranty of habitability may also allow you to terminate your lease early without any penalty. There are also protections for victims of domestic violence, abuse, stalking, and/or unlawful sexual behavior that allow those victims to terminate their lease early and move for their safety. Military orders, and an act of God, fire, so long as it was not caused by your negligence. If you caused the fire, then you can't use that for early termination. Also, if there are multiple warranty of habitability breaches. So let's say you lose water, your landlord fixes it. 3 months later, you lose water again. At that point, you don't have to give your landlord the opportunity to fix the problem, and you can just provide them with a 14-day notice in writing stating that your residence is uninhabitable for the second time within 6 months, and that you are terminating your lease in 14 days and vacating. All right, so moving to, so everything kind that we have been up to this point has been really geared towards renters. Now, the Mobile Home Park Act is more targeted towards those folks who own their homes but are renting their lot sites. So the Mobile Home Park Act is applying to folks that have a tenancy in a mobile home park and also own their home. So what are the additional rights for these tenants? Well, as a tenant, as a homeowning tenant in a mobile home park, you have a right to a written lease or rental agreement. You have a right to your tenancy only being able to be terminated for cause. But what constitutes cause for termination? There's a long list here. The home's not in compliance with local ordinances. You're not following the park's written rules and regulations. The park is condemned or changes use. A pretty significant change this year was they removed as cause annoyance or interference with other guests or management or park management. So that is no longer cause for termination. Knowingly false or misleading statements on your tenancy application. If your conduct, your guest's conduct, a friend's conduct unreasonably endangers the life of a person in the park, they can terminate your tenancy. If you got a friend that comes over and just takes a baseball bat to your neighbor's car, you can lose your tenancy there. Or if someone's conduct constitutes a felony offense or was the basis for a legal action, and that legal action declared your home to be a Class 1 public nuisance. Class 1 public nuisances, things like betting parlors and brothels and bong shops. So those would be kind of three larger categories of public nuisance properties. As you can see, one of the reasons that a park can terminate a homeowner's tenancy is for not following the park's written rules and regulations. But when can the park change its rules and regulations? This is a little bit different than the question that was posed earlier about just generally speaking landlords when they can change rules, because mobile home parks have their own specific laws as it relates to rules and regulations. If you give the park permission to change the rules, they can change them immediately. If you don't give them permission, all they have to do is provide you with 60 days of notice, and they can enforce a new rule or regulation against you. There have been some updates to the Mobile Home Park Act. I'm going to kind of move through these a little quickly so we can get to some questions here. If you're a homeowner, you have a 90-day period to cure any alleged lease violations. Also, if there is cause, then if your landlord is terminating your lease with a notice to quit, they must provide you with also 90 days to sell or move the home. And that 90-day period can also be concurrent with the 90-day cure period. The security deposit cannot be greater than 1 month rent. It also expands homeowner privacy by requiring that the park provide notice to homeowners regarding anticipated entry onto the lot site. There are also some additional changes, but we just don't have the time this evening for those. If you are a homeowner in a park and are concerned about your rights or any actions that park management has taken lately, I would encourage you to apply for additional services and potential advice on the matter. There is the Mobile Home Park Dispute Resolution Act. I'm going to kind of speed through this. This is a what's the word I'm looking for? It's a way to resolve differences without eviction being on the line in the park. All right, so you can file a complaint with the Colorado Division of Housing. The division's going to investigate, facilitate negotiations. If you're unable to come to an agreement, then they'll make a written determination on whether there was a violation. Here's what must be included in that determination. If there's a violation, 7 days to comply with a notice of that violation. They can impose financial penalty. The division can impose financial penalties. They can issue cease and desist orders to stop an unlawful practice, can order a party to take actions to refund monies, filing documents to correct a violation, or taking action to correct a violation. If you disagree with a decision, you can appeal to an administrative law judge. And I'm just going to move through those last couple points to get here to the forcible entry and detainer slides. But before I get started on this, let me just check the chat for questions real quick.
Yeah, Clinton, we've had a couple come in that have been a little specific. There's one about service animals that came in. You go over service animals in a minute, don't you?
I'll touch on that in a little bit, but the Fair Housing Act actually doesn't. The Fair Housing Act actually doesn't discuss. Actually, we'll talk about that in a little bit.
Okay, great. And then we had another question that was pretty specific that we can review at the end of the presentation.
Okay. All right, let me just. All right. So moving back to the eviction process in Colorado, forcible entry and detainer, FED, that's going to be a shorthand all for the court procedure for evictions in Colorado. Landlords, you have to use the court process. You cannot resort to self-help. If you do so, if you resort to self-help, your tenant can sue you. The Forcible Entry and Detainer Act lists reasons you could seek an eviction. Non-payment of rent, lease violations, multiple lease violations, substantial violations. There are also basis for evictions as it relates to the sale of the home or other changes in ownership. So the process itself begins well before court. And the first step in the process of an eviction is receiving either a notice to quit or a demand for compliance. All right, and there's no specific language. There's no state form that's required for a notice or demand. There are specific things that must be included, but they don't have to be phrased in a certain way. So for a notice to quit, it has to describe the property, the date of the termination of tenancy, it has to be signed by the landlord, and it must be served by the statutory deadlines. For example, a month-to-month notice to quit must be served 21 days before the end of the month. A notice to quit for a substantial violation, you can serve, that's 3 days for the tenant to move out. As far as a demand, the only other thing that would be required in a demand that is not required in, or sorry, two other things required in a demand that is not required in a notice. The demand must state the grounds for possession. So as a landlord, you have to tell the tenant, hey, here's the problem. And as a tenant, you have to be put on notice of, well, this is the problem and I have 10 days to fix this. And landlords, you must also give tenants with a demand for compliance the option, I should say, to either comply with a lease or to vacate or to give you back possession. All right. So after that demand period is over, or that notice to quit period is over, the next step is this is when it gets into court. So this is when, as a tenant, you're being served with a summons and complaint. Okay. The summons, that's going to be that's this, just a screenshot over here. That's this document. That's telling you when your court date is. Here in Colorado Springs, we're currently doing non-appearance return dates. What that means is that you've got to get your answer filed by that time or work out some kind of settlement with your landlord by that time. The complaint, now this is the basis. This is what, as a landlord, this is what you're saying, hey, I have a right to a judgment for possession in this case, and here are the reasons that I have this right to the judgment for possession. Now, these documents must be served upon the tenant. They can be served either by personal service, which is where they're handed to you, or if no one is home, if no one is present at the time service is attempted, then landlords you can serve by posting. But you have to first try to personally serve someone. If you are a landlord and you serve a notice or demand by posting, you can only receive a judgment for possession. Now you may think, well, that's what I was looking for. I just wanted a judgment. If this is a non-payment case, you are not then able to pursue a judgment for monetary damages. All right. Now, if you're a tenant and you get a demand that was served by posting, and then you show up to court, you waive personal service, and then your landlord can pursue a monetary judgment against you. So how do you tell a court that this is wrong? Well, you've got to file an answer. And as a tenant, the answer is where you're stating the legal reasons that you should be able to keep the property and that your landlord should not receive a judgment for possession. All right. Now it's legal defenses. Something like I need more time is not a valid legal defense, but saying the notice to quit did not provide me with enough time may be a legal defense. So
Hey, Clinton,
warranty.
Can you hold for just a second? I got one here on self-help. So it says, my understanding of state law is that even if a landlord carries out a self-help eviction, you can still be arrested for trespassing if you try to get back into the property for your things. Do I understand correctly?
No. keep your lease. If you have your lease, and Carla, I can't answer that question. You're going to have to apply. That's a little too specific for me. Okay. But so if your landlord does, if you have a valid lease, and let's say you come home one day and all of a sudden the locks are changed. Well, in this situation, you need to, I would call the cops. Call the cops and show them that you have a valid lease. Because if you have a lease that says, I have the right to be here, and there is no court order saying otherwise, the cops are probably going to tell you to break into your property and just go back in because you have the right to be in that property. So if you have that concern, I would strongly recommend that you keep a copy of your lease either on you or easily accessible, maybe saved onto like an email or on your phone somewhere that you can quickly pull that up. All right. Now, in an eviction case, the warranty of habitability is a defense in certain situations. As we have already discussed, it is a defense against non-payment of rent in certain situations. However, it is also a defense if your landlord retaliates against you for making a good faith complaint to the landlord or a government agency regarding the warranty of habitability, or organizing or becoming a member in a tenants association or similar organization. As a tenant, you can assert the breach of the warranty of habitability as a defense to a non-monetary eviction. Let's say you tell your landlord, I have no hot water and I'm giving you this notice of warranty of habitability. And the next day your landlord gives you some kind of notice to quit saying, you got to be out of here, I'm not fixing your water. Then you have a possible defense against the notice to quit. Now, make sure that you do not miss your court date. If you miss your return date, if you're supposed to call in and you don't, if you are supposed to file something and you don't, you will be at risk of losing and the court entering what's called a default judgment. Most courts are currently operating by phone or virtual hearings. Check your local court's current operating procedures. Here in El Paso County, we are operating virtually at the moment. Now, at this point, we've kind of gone through that trial. Now, if the court has ruled against you as a tenant and in favor of your landlord, then they're going to issue what's called a judgment for possession. Now, 48 hours later, after that judgment for possession, they will then issue what's called the writ of restitution. And the writ of restitution is what allows the sheriff or law enforcement to come into the residence and remove you and your property from the residence. This part, the writ of restitution and the sheriff coming in and removing you from the residence, is prevented by the CDC eviction moratorium. So if you are a covered person, meaning you meet those requirements and you've given your landlord a copy of a signed declaration, your landlord may be able to take you to court and get a judgment for possession and get an eviction, but will not be able to have you removed until after June 30th, 2021. Fair housing. This is the laws that prohibit discrimination based on race, color, disability, sex, sexual orientation to include transgender status, national origin, national ancestry, religion, creed, marital status, and or familial status. There are exceptions to the fair housing law. The exceptions are owner-occupied buildings with 4 units or less, a single-family housing sold or rented without the use of a broker, and housing operated by organizations and private clubs that limit occupancy to its members. There was a question in the chat. Here is the question. This is just kind of as much as I'll get into it for the purpose of this presentation. That's what's a service animal? What's an emotional support animal? A service animal can only be a dog or a miniature horse. The animal must be trained to do work or perform tasks. It is covered by the Americans with Disability Act. This is not a pet. A service animal is the same as a nebulizer or an inhaler. It is a medical device. You cannot deny a tenant his or her service animal. An emotional support animal is not protected by the Americans with Disabilities Act. There are possible fair housing protections as it relates to an emotional support animal. As indicated on the prior slide, landlords are prohibited from discriminating based upon disability if if a tenant makes a reasonable accommodation request based upon a medical condition and an emotional support animal, then landlords, you may have to permit that emotional support animal. So, but what is a reasonable accommodation? Well, first of all, it is discrimination to refuse to make reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. There is no magic language to make this request, but it must be in writing, and it must state what the accommodation is that you are requesting very specifically. And there's a sample letter that is in the materials on the city's website. Here's kind of what that letter looks like. So essentially here, you're saying I suffer from a disability that requires a reasonable accommodation, and I am requesting that you accommodate my disability, excuse me, by providing whatever your specific request is right there. Landlords, you've got to, you cannot make an unreasonable denial here. You don't have to change you don't have to build a new elevator. You don't have to turn your maintenance man into a valet or a chauffeur, but you have to be very careful about if you're denying these things. Now at this point, let's see, I will open it up for questions.
Clinton,
Thank you so much, Clinton. Oh, go ahead, Katie.
We've got a couple people who are asking, at the beginning of your presentation, you pointed to, I see the phone number. Do you want people to send you their specific questions to your email address?
I do not want you guys to do that. You do have that contact number if you want to reach out to me, but if you reach out to me and ask me a legal question, I'm going to tell you that you need to apply for services first. So you can apply for services online at coloradolegalservices.org. You can also apply at extension 444. However, if you call me directly, I will tell you that you're going to have to apply first before I'm able to really do any kind of work on a case for you or look into an issue.
Thank you.
All right, so let me see here. Let's go through, make sure I've gotten questions.
Did you see this one that just came in? Does a new owner have the right to change those reasonable accommodations already in place by the previous owner, since owners have the right to do what they want with their purchased property?
Like most of my answers, I'm going to say it depends, but I'm struggling with that question because to me, what I'm hearing in that question is, can a new property owner come in and deny the tenant the right to deny a tenant the right to the full enjoyment of the property because they're allowed to do whatever they want? And that seems a little inconsistent with the Fair Housing Act to me. So if you are concerned about that situation, please apply. That seems, I can rarely answer like kind of generalized questions, but that question to me seems a little problematic insofar as that I don't think landlords are, just because they purchase the property, it seems to me that they would be knowingly discriminating against somebody by stating, hey, you've made this reasonable accommodation request has been approved. We're aware of it. We're now denying you full use and enjoyment of the residence based upon your disability. So that seems problematic to me on first glance. If you have further questions, please get in touch with Colorado Legal Services to discuss that further. So I'm looking through questions here. I'm not seeing any new questions that are coming up. Does anybody have any other questions for me that we haven't touched on, or were there areas of the presentation that you would like me to go back to review in the remaining time that we have this evening?
While people are thinking of what questions they might have, please do add them. Just before we wrap up, we'll also be reposting many of those web links for the resources that we talked about.
Thank you, Barb. So the question that has come in is there any legal requirement to provide a sample lease to a prospective tenant? There's not a requirement to provide a sample lease. However, there is that requirement to provide you with the signed lease. You are not required to sign the lease, and given the landlord, you may be able to, before you sign it, if there are terms that are not acceptable to you, you may be able to negotiate those terms with the landlord and come to an agreeable term. Because again, this is a contract and you are free to negotiate the contract. Keep in mind that you don't have to accept the contract and neither does your landlord. What is the legality of properties requiring income while in housing vouchers? The question's a little too vague, and I'm not really sure what you're asking. There is the new law regarding a ban on income discrimination. So if a property is most landlords cannot discriminate based upon the source of a tenant's income. However, I'm not sure what else the question is asking there about having income. They're allowed to charge the rent that they're able to charge in most circumstances. No, there is not a legal limit on how much a new owner is allowed to increase their rent. Specifically, Colorado has a law that bars rent control.
And this is Barb. I'll just add, there has been more emergency rental assistance made available, and we'll share that link in a minute. And folks who qualify for that rental assistance, if you've lost income or unable to pay your rent with some connection due to the COVID pandemic, even if you do have a voucher or other public support for rent, you can still qualify for rental assistance for the in your individual portion of that.
So in response to the reporter asking if any renter could stay on after, and asking have I applied for it? Oh, I don't think that question's for me. Now that I'm reading that, most properties require 3 times rental amount. So I apologize, but I'm not really sure what you're trying to ask here. If there is an issue with that kind of rental being running afoul of the Rental Application Fairness Act, it would require a further analysis, which would mean that we'd have to speak further about your individual circumstances, which would require you to apply with Colorado Legal Services. There have not been any court decisions since that Rental Application Fairness Act has been passed, or since the income discrimination ban has been passed, regarding any kind of 3 times rental amount income requirements. Our building was just bought. Should the new owners be providing us with new lease agreements? It depends. If you have a valid, let's say you have a lease agreement that's in effect through December of this year, you have a lease agreement that's in effect through December of this year. All right. Conversely, if your lease agreement expired in December of 2020, then if you're current on your rent, you may want to approach the new owners about working out a new lease agreement. That way you provide yourself with some security over your long-term residency there. But again, if you have a lease that is still valid and somebody else purchases the building, then the new lease is going to likely continue on with the building. If it is a home, there are some different, if the home is being sold, if it's a single family home and it's being sold, you may want to file and record your lease with the clerk and recorder office. As you can see, they're just different. This is why there's a lot of analyses that goes into these cases, because a lot of it depends on the nature of your lease, the nature of the sale, and the nature of the property.
All right, we definitely want to give people a chance to formulate any other questions you have. And again, the slides and the slides will be made available to be sent out to folks afterwards. And will likely be posting this this video to replace the one we have up now, since there's updated information. And then again, if you attended and want to receive the slides but did not use the registration submittal form at the Justice Center's website, you can still do that, and we'll include you on the slides. And any more questions? Going once. Going twice. And as I'm going to say a few things wrapping up. If you think of more questions, please feel free to add them there, and we'll get to them. I really want to thank Clinton Alberts, Deborah Hamilton, Britt Kwan, and Patrick Noonan for presenting this information. Thank you so much to Katie Sunderland for keeping track of all of those questions. I do want to put up some of those final.
Barb, I'll stop sharing my screen now.
Okay, let's see if I can get this up. And then I'll also take these links and paste them in the chat so that if you missed any of them earlier, you will be able to copy and paste them. As I said, we'll send out the slides, post the video. In addition to the registration at the Justice Center's website, the Community Development Division has an email newsletter list that you are welcome to sign up for. We provide information about these events, as well as funding opportunities for agencies and other information around affordable housing and fair housing, and lots of good stuff. So feel free to sign up for that if you would like to get more information. And I want to especially point out, I mentioned this earlier, that First Link Emergency Rental Assistance. The City of Colorado Springs has recently made available new funds from the federal government to help people who have been unable to pay their rent due to the pandemic. And that those funds are, you can apply for them through the Department of Local Affairs for Colorado. If you click on that link, you'll see what the regulations are. There's also, as you can see from the link, mortgage assistance available as well. We really want to get the word out about that. So we encourage people to apply. If you're not sure if you qualify, please do look into that. There will also be more support made available soon for counseling, folks to help kind of walk people through that process. We'll be sharing that information through our email newsletter as well. And then a couple of people asked about and mentioned the packet or the booklet. So the very last link here, I'm looking at two different lists. On the city's website, you can get a copy of that as well. Thank you again to our speakers. If we don't have any other questions that came in, then this concludes our presentation this evening. And we really hope this was helpful. And if you know other folks who would like to attend future presentations, please do pass that information on. Thank you, everyone, and have a good evening.
Hey, Barb, there was a question about the eviction moratorium from the reporter. Did you want to handle that?
Sure. So that is, oh, was this the one about if there's a renter who,
where'd it go? Local reporter here, wondering if any renter could stay on after. I have 1 or 2 questions about the eviction moratorium. Has anyone applied for it? I don't know if there's any renters still on.
if there are any, we'll just leave this open for a minute or two, and maybe you can paste your information. And I'm not sure the best way to handle that. Or the reporter, if you wanted to paste your information and invite people to contact you who have stories to share, perhaps you can do that. Otherwise, you can always contact us, the presenters at all of these various links that we've been sharing, and we can help connect folks if anyone has a short story that they want to share. So with that, we'll go ahead and close out the event. Thank you again, everyone, for being here, and have a great evening.